On WDBO 107.3 FM and 580 AM, Orlando's news and talk. Remember, the answers given on the show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt Law. That's 1-800-339-4885, or visit us at DeWittLaw.com. As always, if you have legal questions, go ahead and send them to us at askask@DeWittLaw.com, or you can leave us a voicemail at 407-536-6737. But today, before we get into any questions or anything like that, we have a very special guest on the show, a man who you may have heard on the radio in Central Florida for many years now, and who's also another very experienced family law attorney. We have Ray Traendley from TK Law. Ray, thank you for being on the show today.
Thanks for having me.
Of course. And, you know, some people may think, well, you know, the DeWitt Law Firm also does family law. Why would you have another family law attorney on the show? And that's exactly why I wanted to have you on the show here today was, you know, oftentimes I think when you're going through a divorce, when you have a family law matter, it's very contentious. It can be very litigious. And I think there's kind of a stigma out there that you want an attorney who maybe hates everybody else.
Sure.
And is going to burn everything to the ground. And, you know, Ray and I have worked on many cases together over the years. I don't know why, but you seem to be on the other side of a lot of our cases here.
It seems like we overlap a little bit.
We do. And so, you know, I kind of wanted to talk about, you know, the benefits of, you know, having an attorney who can work with opposing counsel amicably and how that can kind of benefit you in a divorce. And I know you've seen horror stories of divorces before. You've seen the scorched earth approach, and you've also seen the more, you know, collaborative or cooperative approach. So, you know, in your experience, kind of, you know, which one do you see being more beneficial to people? It's obviously a loaded question, but and kind of how?
Well, you know, I think the best part about having a good relationship and a good rapport with the other attorney is you can generally find more flexibility in a negotiation and you can find more common ground. And so I had a mediation just earlier today, and the other side, and I won't say who it is, but it's one of those attorneys that you just kind of know when you go into the mediation that if you can bridge that divide, it's going to be a miracle.
Yeah.
And so, you know, I try to set my clients' expectations of this is what I think the best case scenario with this judge is and the worst case scenario with this judge is. But when I'm doing that prep and I'm having that conversation, I also have to say, I think that we're going to end up closer to your worst day in court if we're going to settle. And it's a hard pill for a lot of people to swallow.
Right.
And unfortunately, the selection of attorney really is going to determine how close you're going to be in a negotiation. And so, you know, if both parties hire somebody who's going to be scorched earth, then you really know the outcome instantly, right?
Yeah. You're going to be going to trial.
You're going to trial, and it's going to be whatever the outcome is, the outcome is. And that's okay. Like, there are some families that need that.
Yeah.
Because they're never going to find common ground. But the ones where, even if there's just a chance that you can resolve the issues, meaning you still believe that the other person's a good parent, you still want to make sure that person succeeds. You know, let's say you're representing the husband and it's a stay-at-home wife. Like, he doesn't want her to be homeless. He doesn't want her to be living in a bad neighborhood, taking care of the children. If there's that chance, the best thing you could do is to recommend to the other side, hey, why don't we get together and why don't we set the criteria for how we're going to select an attorney? And if you can find a lawyer that works well with another lawyer, that's amazing. And the very first question I ask, and I don't know if you do the same thing, the very first question I ask when I meet with a new client, who's the other lawyer?
I'm always curious to know who the other lawyer is because it sets the tone of the case.
It really does. And so, you know, it just changes so many things. And you know, there are some lawyers, like, I know I can call you on a case and say, hey, Mo, this is not a strong legal position, but I think that we can work something out. And I think that this is how it meets your client's goals. And you can go to your client and you can say, hey, this is the idea. Here's how I think we can use it to our benefit. And when you have that collaborative conversation, it's not a linear negotiation where I'm over here and you're over here and we meet somewhere in the middle. Instead, it's what's the most important goal to you? This is the most important goal to my client. And sometimes you can come up with a win-win.
Right. Yeah. How do you achieve an outcome that benefits both parties here?
Right. And so, you know, in the case today, I really tried finding that win-win. And for my client, the win-win was the wife was going to retain the house. He was going to give up all the equity in the house. And in exchange, the children would stay in the school district. and that would obviously help him on the back end with alimony, right? That was
Right,
the thought
yeah.
process.
Yeah. So she gets what she wants. The kids benefit. He doesn't have that monthly alimony payment or a reduced version of that, and so everybody kind of leaves happy.
Right.
Which is, on the scorched earth technique, if you go to court, and I always tell, this seems like an obvious thing to say to people,
Sure.
but there's only two ways to resolve a case. Either the parties settle it, or you go to trial and the judge makes the decision for you. And in most cases, in my experience, nobody's ever 100% satisfied.
Absolutely.
With what the judge does in family law. There's really, a question I'm sure you get too is, what's your win percentage?
Right.
And my response in family law is always, nobody wins in family law.
Yeah. I actually say the exact same thing.
Yeah.
It's if you ask win loss, the answer is I lose every case. And that's
Right.
because no matter what the outcome is, you're losing time with your kids.
Yep.
You're losing some of your assets.
Right.
You're losing maybe some of your reputation, right? You're losing something just by the very nature of a breakup.
Yeah. You lose half your assets, half your time with your kids. I mean, that's kind of what
Right.
happens as part of a divorce. So you're right. Nobody wins there. But the idea behind it is, when you go into mediation, and mediation pretty much happens in almost every divorce or family law
Yeah, absolutely.
case. And for those who are listening and don't know, mediation is just kind of a fancy term for a settlement conference. You
Right.
sit down, you have a mediator who's a third party neutral who kind of tries to help facilitate negotiations. But you're just trying to reach an outcome that works for everybody. And, I've had clients who come into mediation with, an attitude that I'm not agreeing to anything. And if you have that attitude, then ultimately you do end up in front of a judge. And often you're not happy with what they say either. And then you want to appeal, and that costs you more money. So, having an open mind going into mediation, I think helps everybody a lot more. And I think also sometimes it's the attorney's job. And I've seen, other attorneys make this mistake a lot where the client has unreasonable expectations and they don't step up to the client and say what the realistic expectations should be.
Absolutely.
Instead, they let the judge do that, and then they get mad at the judge. And, I'd rather have the client be mad at me, frankly, save the money, save the headache, and actually know what the realistic expectation is. And then if they still want to go see the judge and make the judge tell it to them, that's fine too.
I think what happens is a lot of times people are either one, afraid of losing the client, or two, sometimes people want to avoid the conflict that comes with giving the hard reality.
I think that's true.
And the way I've always looked at it is if we're on a team together, right? Let's say we're playing basketball.
Yeah.
And I really think that I should be the shooter and you should feed me the ball as much as possible. And you think you should be the shooter and I should feed you the ball as much as possible. If we don't ever communicate, the team is going to suffer,
Yeah.
right? And I really look at the attorney-client relationship very similarly. We are a team, and we should be able to communicate freely and say, hey, listen, when they're running this coverage, you feed me the ball. If I see you, in this situation, I'm going to feed you the ball. And that's going to help us both score more points.
Mm-hmm.
And so I've always kind of taken it upon myself to be the selfish one and say, listen, like, I'm making this about me. I want you to win because that makes me feel good. The whole reason I do my job is I get to help people.
Absolutely.
And so I want you to win, and the way you're going to win is you're going to set yourself up for success. And you're not going to be setting yourself up for success if you think you're going to score 70 points on the Denver Broncos every week.
Right.
It doesn't happen.
Right.
But if you've got reasonable expectations and you're willing to be flexible, I can make a lot of magic happen. And I think part of the reason why you and I have bonded over the years is we have had clients that are tough.
Oh, yeah.
We've had cases that were very tough, actually.
I can think of a few off the top of my head.
Me too. And we're able to care enough about our clients and the outcome that they're going to achieve to say, hey, have you thought about this? And it's not always the easy answer, but it's that creative answer that a judge isn't going to be able to give you that might create maybe not a full win-win, but maybe not a loss-loss, right? Yeah. And I think that's really where that dynamic can really play in,
Yeah, because, sometimes the other thing about mediation is, you can be much more creative in mediation.
Absolutely.
The judge is confined by the statutes and by the case law that they have, and they really can't do a lot of the creative things that we can do in mediation. So sometimes when somebody forces it to trial, it is just a loss. I mean, the judge doesn't have any choice but to do something that doesn't benefit everybody, frankly.
No, you're 100% right. And you know, I like mediation. Like you said, mediation is just kind of the settlement conference where we're talking back and forth, but it still has enough rules to it,
Right,
to where everybody's committed to a process. And again, I go back to the team analogy, is in that situation, assuming everybody's on the same page, which is we want to control our destiny and come up with a solution that a judge can't come up with, it's the best process. You know, the mediator's job is to push both parties towards a compromise. And sometimes when you don't have a very strong lawyer on the other side, that mediator can kind of be the equalizer to say, okay, maybe you should think about it a little bit differently. Let's say your judge really doesn't like your argument.
right.
What do you do then? Are you okay with losing custody of your kids because you really want to have that 5 extra minutes on the phone with your kid once a week? And if the answer to that's no, then that's where the compromise is born.
Yeah.
You know, so I'm with you, man. I think mediation is a great process. Speaking with your spouse about who they're going to hire is so important and underrated. And I think considering what kind of future you want to have down the road, those are probably the 3 biggest things that you can do if you're trying to resolve your case. Because if you don't want a future where you guys have separate weddings and separate graduation parties.
Oh, yeah. And I know, you know, we all know somebody whose family operates that way.
That's right.
Yeah.
And so, you know, just think about what that future looks like. And not every family is the same. Not every
Right.
case is the same. But, you know, I think our job is to help our clients. And that's the power that we're given as lawyers.
You're absolutely right. And I think, you know, that's also the power of having good attorneys on both sides of the case. You know, I can remember a case that I mediated where one side was a doctor, and because he was a doctor, he had a relationship with a personal injury attorney. And so he hired one of the associates from the personal injury attorney to handle his divorce, which was pretty complicated. And so we mediated on a Saturday, and we were there till about midnight, and we had an agreement, and it was midnight. And this was under the old alimony statute where it was, you know, tax deductible to one party and
Right.
taxable as income to the other. And the attorney started arguing that we had to remove that provision. And I'm going, well, that's the IRS code. That's the way it's treated. I can't remove it. And it became this big argument, you know, and this is midnight. We're exhausted at this point. That blew up the entire deal. And we've been there for God knows how long, how many hours we've been there at that point. Just because, you know, the attorney, and they were a nice attorney, they were a smart attorney, they just didn't have the experience in family law to know these kind of intricacies and to know, hey, where do I want to, you know, press here? Where do I need to press to get my client what they need versus just making arguments for the sake of making arguments?
Right. Well, and I think that's another it's another one of those life lessons, right? I remember a case I had with your mother years ago, and my client didn't have the most reasonable expectations, and I didn't do a very good job of setting the expectations, but we were at mediation and we were discussing a point, and we took a position because we thought it would build leverage. And it ended up backfiring, and we ended up settling the case at the end of it all. And it was one of those 11th hour, like the pretrial conferences tomorrow, settlements.
Yeah.
We ended up settling the case, but I'll never forget, you know, your mother kind of pulled me aside at mediation, and she said something to me at the time I didn't respond well to. I took it more personal. She said, you know, where are we going with this? And I look back on that as one of those really key lessons that at any given point in a negotiation, it's not always about leverage, and it's not always about positional bargaining. Sometimes it's, are we still going in the right direction?
Yeah.
And so I keep a compass on my keychain, and I keep a compass in my office, and it's like to always remind me, like, are we going in the right direction?
I like that.
And so, you know, it's one of those things that's really easy to get lost in when you're emotional about it. But that's what we're there for. We're there to be unemotional. We got to help guide people.
Absolutely. Absolutely. And we do have to take a quick break, but you're listening to DeWitt Law Review right here on 107.3 FM and AM 580. We'll be back with more with Ray Traendley after the break.
The statute of limitations in Florida for filing a personal injury lawsuit is now 2 years, which means you have a very limited window to bring a claim. So if you're in an accident, you don't want to wait. Cases do not get better with age. You want to contact an attorney right away and start that process.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580. I am once again joined by Ray Traendley from TK Law. And Ray, where can people find you if they want to reach out and talk to you?
So you can go to our website, onefirmforlife.com, or you can call our office at 407-834-4847.
And, you know, we're having Ray on the show today because Ray is another family law and divorce attorney right here in Central Florida who's very experienced. And, you know, we've had a lot of cases together, like I said before. And we've battled against each other, and we've also, you know, reached some good agreements that really benefited people. And so that's why I wanted to have him on the show here today, because not only is he a wealth of knowledge, but also I think there's a lot of insight to be learned by having attorneys who can work well with others, who know how to reach agreements with others, know when to fight for the client, but know also when, hey, maybe this is in the client's best interest to try to resolve the case.
Well, and I think you and I have always really seen our role as lawyers very similarly. And I think part of what I think you and I are charged with doing is we got to change the perception of lawyers in the state of Florida, in Central Florida, in general, because I think a lot of lawyers historically have been seen as gladiators.
Right.
Right. It's either you or the other guy, and somebody's going to die, somebody's going to survive.
Yeah. And in some areas of law, maybe that's fair. You know, if you're facing life in prison, I mean, maybe that's the way you have to do it.
You know, there's always some gamesmanship,
Right.
you know, when you're in the courtroom, but outside the courtroom, you know, again, I think you and I've always seen it as,
Oh, absolutely.
we need to be doing better for our profession.
Absolutely.
And there's always those horror stories of lawyers and things like that. And so you and I have always really bonded over that. And I think, you know, you've invited me on the show, and I'm incredibly grateful and appreciative of that. But, you know, I think what you're doing with the radio shows and what you're doing with all the stuff that you're doing on social media, it's so important, because people need to realize that there are actually lawyers out there that care and that want to do good work, and that you've really kind of made it your mission to get out there and let people know, like, hey, we can be friendly and approachable too.
Oh,
and
absolutely.
if you want a lawyer that's going to be stuffy and maybe not treat you well, maybe we're not the right firm. But if you want somebody who's going to treat you like family and take good care of you, better call Mo, right?
And I mean, and call Ray as well. I mean, that's why your firm is, you know, one firm for life, because you want to be there for the life of the client and help them along the way. I mean, you know, when I was a young attorney, I had a hearing over here in Orange County, and the other side won the hearing, but then and this is actually a lesson I learned. They got in the elevator with me and they tried to fight me in the elevator.
Oh, wow.
Another attorney actually stepped in the middle and pushed the guy away from me because he was so angry that it wasn't that, I mean, I lost the hearing. He won it, which is still mind-boggling to me why he was so upset. But he was upset because he thought it was going to be an easy case for him to win, and I was putting up a fight for my client just with the defenses that I thought
Sure.
were there. And, you know, sometimes I think lawyers get so disconnected from reality of what their job really is.
Right.
You know, I mean, yes, we advocate for the client, but also, you know, that case would have probably settled even before that hearing had that person just been a, you know, halfway decent human being, but also a decent lawyer,
Right.
and tried to resolve it rather than, you know, figuratively and literally trying to take the gladiator approach.
Well, and you know, I think about it all the time. How can I get the outcome that my client is looking for? And I think that if more lawyers were thinking about that and thinking less about, you know, how can I better my position or whatever the case may be, or maybe bill more hours to a case, I think that we would have a different relationship. But there are some of those attorneys that they really don't get their role, and instead they want to be gladiators instead of problem solvers.
And that, I mean, you hit the nail on the head. Our in my mind, at least, our job really is to be the problem solver.
Absolutely.
And, you know, oftentimes, you know, somebody in our office will ask us, well, what do I do with this offer? I go, the first thing I always ask is, what does the client think?
Yeah,
Right?
absolutely.
Because it's the client's life. You know, we get to move on to the next case. The client has to live with whatever the results or the outcome are. So, you know, it's not our job to tell them what they're okay or not okay with, especially when it comes to your family and things like that.
Sure.
That's on the client.
Well, and you're right. And again, and I'm sure you've said these words too, so this isn't news to you.
Yeah.
But, you know, at the end of the day, this is your relationship with your kids.
Right.
And this is your ability to put food on the table for your family. And this is your ability to move on. I'm just trying to tell you what I think your options are.
Yep.
And so, you know, I'm trying to be as creative as I can and trying to problem solve. But, you know, it is their life, and it's it's a really serious responsibility. I don't ever ask anybody to feel bad for me because I'm a lawyer.
Right.
But
Yeah.
I do think recognizing that a lot of us lawyers do really think about what's the impact on the back end. Is this going to be something where they're going to have problems in the future? And that's the stuff that keeps us up late at night.
Oh, absolutely.
And I know you and I have talked about that exactly.
We have many times.
Yeah.
But we're up against another break. We'll be right back. This is the DeWitt Law Review on WDBO 107.3 FM and AM 580.
And I got hit so hard that it spun 180 degrees facing the way that was coming from. Every Friday morning I go and pick up bagels for my sons. It was raining that day. Left-hand turn only lane and just waiting for the arrow to turn green. Made it about 3/4 of the way up and just got hit from the side. Didn't see it coming. For a few moments, I was just like, what had happened? I started to look around, saw that one of my windows was blown out, the airbags were out, and realized I was in a car accident. I was able to move my vehicle and get out, but then as soon as I got out, my neck was just in pain. We ended up going to my primary care doctor, went through the evaluation and all that, but the pain just wasn't going away. Luckily, it could have been a lot worse, but it still leaves me vulnerable to this day. I just remember a friend from the radio suggesting that I just call Mo. He picked up and talked to me. He was at a conference, I think. Talked to me and set everything up for me. The process was awesome. Any questions that I ever had, it wouldn't even be a day that they would get back to me. They put me at ease when it came through the whole thing. You know, the process was almost 2 years, but at the same time, like, I felt like I didn't have to worry about anything. Like, I knew that they had everything under control. I would definitely recommend Just Call Mo. Like, it was great working with them and having them work for me. Like I said, it took a lot of worry off. So yes, I would definitely recommend Just Call Mo. If you're injured on the go, just call Mo.
Welcome back to the DeWitt Law Review right here on 107.3 FM and AM 580 WDBO, Orlando's News and Talk. I am attorney Mo DeWitt, and once again, I am joined with Ray Traendley from TK Law. Ray, how are you doing?
I'm doing great.
All right.
This is a good conversation.
I'm loving this conversation. I hope the listeners are enjoying it as well. And, you know, because you were kind enough to come on the show, again, if you would, just tell people, again, Ray's a very experienced family law and divorce attorney here in Central Florida. And, you know, there's plenty of business to go around to all of us, and I can't represent everybody. So, you know, if you need somebody, Ray, how can they get a hold of you?
If you got a conflict, you can find me at onefirmforlife.com. And, you know, I can't say enough about the work that you guys have done in growing the firm and the practice. And I consider myself to be pretty lucky to call you a friend.
Well, I do the same. And you guys have grown quite a bit as well over the same time. I think we've kind of, we're probably came out of law school around a similar time, if not the same year. And so, you know, it's kind of been nice to see each other grow over the years.
I agree. Absolutely. And we all have like mentors and people that have kind of raised us up as baby lawyers. But I don't know. I've always enjoyed our relationship a lot.
Absolutely. I completely agree. Couldn't agree with you more. But anyways, back to the substance, the family law stuff.
That's right.
Yeah. Why I think listeners listen, or
Maybe.
who knows why they listen. Maybe they just like our voices. I don't know.
It's a very soothing voice.
But anyways, you know, a lot has changed in family law this year. We've had a new alimony law come out that's, you know, been proposed, I don't remember, 3 or 4 times previously. It finally got passed this year. There's new law regarding time sharing that's, you know, substantially changed, you know, the way you handle time sharing, also, you know, commonly referred to as custody cases in the state of Florida. So in your office, how have you kind of seen that impact the clients and impact your practice?
You know, so we're still figuring out the alimony stuff, you know, so
Right.
The new alimony law, for those that don't know, is we basically set a cap for like what your worst case scenario is going to look like if you go see a judge. And so before the law change, we had a lot of different ideas about how you calculate alimony. There were some cases that said, don't make it more than 50% of somebody's income. There were some other cases that said, don't make it more than 35%.
Right.
And then the American Academy for Matrimonial Lawyers said, well, hold on, we've got this formula where we take the net difference and 35%. And actually the new statute reflects that. But instead of saying that's the amount of alimony, we've given courts the discretion to still figure out what the need and ability to pay is. But what we've said is we're going to create a formula that it's not going to be greater than blank. And I think the best part of the new law was not just that part, but the bit of advice I used to give people, which is you're never going to have the same lifestyle after the divorce that you had before the divorce.
Right. There's kind of this misnomer where, the standard limit living
Right.
during the marriage should be maintained. But when you take one household and split it into two, that's just not feasible. It's
Right.
not possible. There's just not enough money to go around, frankly.
2 mortgage payments,
Right.
2 utility payments, 2 everything
Yeah.
payments. And so if you only got one pot of cash that's coming in, it just doesn't make any sense. So it's really given, I think, me some flexibility in not only negotiating outcomes for my clients, but we've had a couple of cases that have gone to trial using a new alimony statute. And I think there's a greater appreciation from the bench that the numbers that we're using are more realistic. I know you've been there before.
Oh, yeah.
Where if you want to be the recipient of the alimony, you come up with a figure that's like, listen, if this guy never went to McDonald's ever again,
Right,
and he only
right.
drove 10 miles a month, he would have the
Stop
ability
taking those toll roads.
right. He'd have the
back
ability to pay
roads.
$10,000 a month.
Yeah.
And the guy's like, but wait, I only make $11,000 a month. And you're like, yeah. But if you didn't spend any more money, that's your ability to pay.
Yeah.
And then on the needs side, you kind of do the opposite. And so I think the hard part for judges is they have to have competent, substantial evidence. So they need to have a number to base it off of. And when we did that and we kind of came at these opposite spectrums, judges were almost forced into a situation that they shouldn't be in, which is guessing what the number is.
Yeah.
And so at least this has given us a cap on it, and the judges then know, okay, I don't have to deal with extremely unreasonable numbers.
Yeah. I mean, it's not as rigid as like a child support formula, but
Right.
there are at least some guidelines associated with it.
And the thing that I've seen, it's interesting. Lawyers have a way to complicate everything.
Of course.
And so the thing that I've seen is, and I've seen it before, but really arguing how to calculate the net number has become a real new emphasis.
Yeah.
And so now I've almost kind of create four possibilities, and I use different net numbers for the calculations. And then I also use some derivatives based off of the ability to pay as some of my calculations, just because I'm finding new and creative ways that people are arguing how you should calculate a net number, even though we
Right.
have a statute.
Yeah.
Even though the IRS has told us how to calculate net numbers. It just, we had to find a new way to argue. So that's interesting to me.
Yeah. I mean, it's definitely, there's always going to be creative arguments made. And, right now, because this is so new, it's just kind of hitting the trial courts. Right. And so, the judges have to make decisions on this stuff where they don't have the guidance of case law. And so, typically what happens is, when there's a new statute out, the trial court judges make decisions on it. And then some of those cases get appealed up to the appellate courts. And the appellate courts are the ones who make the case law. And that's what, governs the law and the
Right.
judges follow. But we don't really have that yet. So in a few years we will, but, appeals aren't quick. They take time.
So far, knock on wood, we've only had one case where we filed a motion for rehearing on. That case was unique in the sense that the particular issue in the case was an imputation issue. And so the payor was 63 years old. And so the new statute on alimony also says that we presume a reasonable retirement age.
Right.
Which has historically always been 65.
Right.
The person retired at 62. There was some evidence introduced that there was an agreement between the parties that my client was going to retire at 62.
Okay.
And so we thought that there was a really good argument that he should not be imputed at this exorbitant rate, and that the court should calculate alimony a little bit differently. And really, we wanted lump sum alimony, just just to throw it out there. And the court disagreed, and so it's a unique issue that I think we will probably lose on a rehearing on, because I know the judge. And it'll probably end up being an appeal. Well, hopefully we get some really good case law out of it, because it's an interesting issue, because they've said reasonable retirement age.
Right.
But what does that mean?
Right. Yeah, because a basketball player, an NBA player, has a very different reasonable retirement age than an engineer or an accountant.
Well, and my guy was in construction.
Right. Yeah.
And that's a hard
Tough work.
job.
Yeah.
Yeah, absolutely. And so, I think we had some facts there that went our way. I think the doubt that was cast by the other side is reasonable, but I don't know if it raises to the level of abuse of discretion. I'm not sure, but the appellate court will figure it out, and then we'll have more guidance on what does that actually mean. When their legislature is writing these laws, they're writing them for lobbyists.
Right.
They're not writing it for the judges who are then going to be interpreting the law at some point.
And oftentimes they raise more questions than they do answers.
Absolutely.
For the judges. And I think, what was it, last year they kind of rewrote the entire statute at the last minute.
Right.
And then tried to pass it. Ultimately, that one got vetoed, I believe. But these things can change. And you also have to consider the legislative session is fairly short. I think it's like 60 days or something.
And that's a lot of work to do in a short period of time.
A ton of work. And so you're having these very complicated statutes. Some people who are working on them are experts in the field. Some have no idea about the field.
Yeah.
And so they're trying to figure out these statutes that are going to change the lives of millions of Floridians across the state. And they don't always get it right. And then the judge has to take this statute, and they have the difficult time of interpreting it. And sometimes you have to do a statutory interpretation where you even look at the legislative session and what they discussed and what they meant, and dig into all those kind of fun things.
Absolutely.
To try to figure out what on earth they actually meant by this.
Well, and the one that really stands out to me, for 25 years, alimony never considered the idea of retirement. For 25 years.
Right. And it didn't until the case law came out.
Right.
Yeah.
And right. One case kind of came out, and the Supreme Court said, yeah, that's good. That makes sense.
Right.
But it took 25 years for the legislature to say, hey, maybe we should add this actually to the law instead of letting these lawyers make it up,
Which is an absurd, idea that alimony didn't stop when you retired.
Right.
I think, it essentially made people work until they died for the most part, because you couldn't afford to retire because you had to pay the alimony. You didn't want to get held in contempt of court or anything like that. Or you had to build up a lot more in savings in order to pay the alimony.
Right. And then the court makes a determination at that point that you still have the ability to pay because you've got this, this stack of cash on the side. It was just very backwards.
Yeah.
And so when I tell people stuff like that, and they're like, oh, the legal system, is it really designed perfectly? And the answer is no. We're still figuring it out.
Oh, absolutely.
It's called the practice of law for a reason. We're still just practicing and figuring it out.
Yep.
But I do think that it's a pretty good adjustment and compromise that when we start getting some of this case law and some of the interpretation, I think it will be overall a much better system for people.
I think so too. It obviously takes time. You have to get the case law out there that clarifies the statute, and that does take years for the appellate court to determine and make rulings on. But I agree. I think we'll have a much better guidance for alimony going forward. I mean, one of my favorite cases was a case where I represented a doctor, and he had gotten permanent alimony back when the statute was the wife was awarded permanent alimony after 10 years.
Right.
And so he had been paying permanent alimony so long. I want to say he was maybe his late 60s, early 70s when I was representing him, where we walked into the mediation room, the waiting room area, and he goes, "Who is that?" And I go, "That's your wife." He didn't even recognize her. He hadn't seen her that long. But at the time, even though I think he had just retired or was about to retire, but he had such, he had a good net worth. He had a lot of investments and savings that, he still generated a good amount of money off of passive income to where he was able to reduce his alimony, but he didn't eliminate it completely. So he paid alimony probably 5 or 6 times the length of the marriage, just because that's what the law was at the time.
Right. And that was an option, going back to why mediate and why go to trial, part of the problem, right, is if you go to trial, the judge is stuck with whatever the law says.
Yeah.
And so, you can mediate and come with an agreement where you can build in some language on the back end, and you can say, even if the law doesn't say it, you can say, hey, when you retire, this goes away. Mm-hmm. And that's, you and I probably have talked about this before, the idea of like lazy lawyering, right? Where like you just do the bare minimum to put into your agreements. And, it's so frustrating because, again, if you're thinking about these issues and you're talking about them and you're considering these alternatives, you can really be so creative and build in so much protection on the back end. Maybe you can't guarantee how it's going to turn out, but
Right, you can never
arguments.
guarantee it, but yeah.
Yeah, you got arguments.
Yeah, I mean, I had an attorney yell at me one time because my divorce agreement's 27 pages, and I go, well, that's to protect both clients
Yeah,
because that
absolutely.
eliminates future litigation, and that's the entire idea behind this. Is when the case is resolved, you want it resolved permanently.
Absolutely.
And under the old alimony statute, if you were married over 17 years and you went to trial, the judge really didn't have any choice but to award permanent alimony. You can make the argument, but very rarely could they really do it. And that's why, in mediation, oftentimes you try to negotiate a termination date,
Right.
because it saves the parties having to go through another set of litigation, which, fortunately under this new alimony statute, I think a lot of that's going to be eliminated because it has more of an end date, although there's still probably some open-ended areas there. But hopefully that will be improved where, people can stay out of court more because nobody likes court, the more you're in court, it's more stress, it's more money. It's kind of time lost in your life almost.
I agree with you. And I think, you and I probably have both had clients that we've represented for years on end in litigation.
Oh yeah. There's boxes around this office that prove that.
And if you ever talk to them on the back end and it's like, hey, like what toll did that take on you? How much do you wish you could have avoided some of that stuff? And I think they all say the same thing. Like maybe some of them felt it was necessary, but none of them would want to do it again.
Oh, absolutely not.
I've got cases where, we won sole custody back when that was a thing.
Uh-huh.
And it's still like the exhaustion and the time and the energy and the money. It's hard on people.
It is.
The analogy I use is it's like going surfing and then getting swept underneath the wave and almost drowning, right? Like you're glad you survived, but
Right.
you don't want to do it again.
No, absolutely. I mean, it takes a toll on the family. It takes a toll on the kids. It certainly takes a toll financially. And you're right. In certain cases, it is necessary, but there's also the cases where people want revenge.
Oh, absolutely.
And there's attorneys out there where you can call them and you say you want revenge, and they'll take it and they'll do what you want. When somebody tells me at least that they want revenge, I say, look, if you want me to be your attorney, I'll be your attorney, but I'm also going to give you the advice of, look, this is your best day in court, this is your worst day in court, and this is what you need to do to get the best outcome in this case.
Right.
And so, a scorched earth technique, a revenge technique, I've never really seen it go well, frankly. Very, very rarely does it actually go well.
I will say this. It depends on what your definition of well is.
That's true.
I had a scorched earth case where the husband just wanted to stay married.
Okay.
And they stayed married for like 2 years while the rest of the family fell apart. And I felt bad for my client because all she wanted to do was get out of it. And he knew that, So, I mean, he lost everything, right? He lost the house. He lost the kids. He lost, all the things that we could quantify and say he lost. But he stayed married to his wife for another 2 years, which was his goal.
Yeah.
And so I think you're right. I think you have to set the expectations and the priorities and the goals. But unless your goal is like that Pyrrhic victory, it's not going to work out for you,
Well, we're up against our final break, and we'll be back with our final segment right after this. You are listening to DeWitt Law Review right here on 107.3 FM and AM 580 WDBO. I'm attorney Mo DeWitt. I am joined by attorney Ray Traendley from TK Law. If you want to reach out to Ray directly, go to onefirmforlife.com, and we'll be right back after the break.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney. So I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to the DeWitt Law Review right here on WDBO 107.3 FM and AM 580. I am attorney Mo DeWitt, joined by attorney Ray Traendley from TK Law, onefirmforlife.com. Ray, thank you again so much for being here. It's always great to have other attorneys, other professionals join us on this show. And I think it just gives the audience more perspective. So again, thank you so much for being here.
Thanks for having me.
Of course, of course. And so, we were talking about some of the new laws that have affected family law this year, have affected divorce cases, certainly. We talked about the alimony statute, and one that I don't think has gotten quite as much publicity has been the change in the time-sharing law. And so, now there is a presumption for equal time-sharing or 50-50 time-sharing, which we didn't have here in Florida before. I mean, how have you kind of seen that affect your clients in your office?
I think it becomes very regional. I think that there's still judges and attorneys, depending on the region, that kind of go back to the dad gets every other weekend type mentality. But I think overall, me saying that both parents should be entitled to equal time sharing isn't hitting against a flat brick wall anymore. Right? There were times, and I know you've been there too, where you say, hey, dad coaches all the sports and dad's at every event and mom is involved in all the schoolwork. They should get 50-50. Mm-hmm. And the other side says that's never going to happen. And it was just like you were hitting a brick wall.
Yeah.
So I think, from my point of view, it's been really helpful for the legislature to say, hey, lawyers, cut it out. Don't encourage these two people to fight over, 24 hours or even 8 hours. Because a lot of times it's that overnight.
Oh, yeah, absolutely.
And so let's be realistic here. Let's figure out a way to make this equal. And I think the other part of that is saying that fathers are natural guardians in the paternity context has really changed the context of my conversations as well, because I still don't think that means what the legislator wanted it to mean.
Agreed.
But it gives me the ability to say, this is what the statute says. You need to be reasonable. And if you're not reasonable, I'm going to go to the judge and say, you need to pay my attorney's fees. Right.
Yeah.
And that's where I think it balances itself out.
I would agree with you. And I don't think the paternity statute is fully there yet, because there's still a lot of hurdles, and you have to do the affidavit, all that kind of stuff, which we've been talking about a lot on the show because I want people to know about it.
Absolutely.
I don't know that people still know to even do that if, they have a child with someone and they're not married. But the presumption for 50-50 is a pretty big thing. And, I used to say that most judges start at 50-50, but you're right. It depended regionally. It depended which judge you got. It could be the same county, and just different judges had different perspectives of what a father and mother's role should be in a child's life. So now, the conversations that you have when people are saying, well, I want full custody, are obviously very different, because there's a presumption of equal time sharing. And, we've had a few cases with that so far, but the contested time sharing or custody cases are some of the hardest cases, I think.
They are. And I think being a parent has changed my perspective on it. I don't know if you feel the same way.
Absolutely. Absolutely.
I mean, I look at it as almost under no circumstances, except in an abuse or neglect type scenario, do I really think a judge is the best person to decide what happens with a kid?
No. And I mean, I'm sure you've had this too. So many times I've had a case where one of the parties insists, I'm not going to agree to anything. I'm going to the judge. This is what I want. The judge makes a time sharing schedule that works for nobody.
Right.
They've gone all the way through trial, and then they have to go back and do a settlement agreement because the schedule doesn't work.
Well, and I know you've always been pretty reasonable, especially on the kid issues, because again, we've litigated a bunch against each other. But I mean, how has being a parent changed the way you look at these time sharing issues?
Well, I can't imagine not seeing my child for 3 days or 2 days even.
Right.
on a consistent basis. And, you know, even doing a week on, week off and not seeing my child would be just heartbreaking, frankly. Now, obviously, that's the reality for a lot of divorced parents. But, you know, I think having the presumption of equal time sharing, at least you're starting from a place of fairness, except in cases, like you said, of, you know, abuse, abandonment, neglect, you know, substance abuse, kind of really serious issues. But otherwise, it's very difficult to even fathom not being able to see my child.
And, you know, that feeling. So that's the one I try to really lock on to when I'm talking to people, because, you know, you mentioned the word fairness, and I try not to use the F word when I'm talking to clients. But when you're talking about fairness, it is not fair that you're going to lose half the time with your kid.
Yeah.
But, you know, there are logistical and practical limitations, and you're not going to want to be hanging out with your ex-wife or your ex-girlfriend every single day so you can see your kids actually 50-50, half the day, every day.
Yeah.
You know, you're going to start dating. They're going to start dating. It gets real awkward real fast.
New spouses, whatever it may be.
And so it won't be fair, but what it will be is it'll be equal.
Yeah.
And you'll both be equally valued. And I think that, you talk about like that feeling of like, I could spend a week away from my kid. I think that's one that we need to really embrace as lawyers, because again, I can never put myself 100% in somebody's shoes,
right?
But I can at least recognize that's a really crappy feeling, and I don't want that for them.
Yeah, it's very tough. I mean, honestly, I think we could probably talk for hours on this. Unfortunately, we are out of time. This is the end of the show, so we got to wrap it up. But again, Ray Traendley from TK Law, onefirmforlife.com. Ray, thank you so much for being here.
Mo, I'm very appreciative of this opportunity, and again, continue to do what you're doing. You're doing a great job.
You as well. You as well. This is the DeWitt Law Review. We will see you next Sunday at 10 a.m. right here on WDBO.